I'd like to welcome you to the second annual Belle R. and Joseph H. Braun Memorial Distinguished Lectureship Series. My name is Ronald Domsky. I serve as a professor of law here at the John Marshall Law School, and also I'm chair of the Braun Lectureship Committee this year. This series of lectures is funded by a most generous gift from the Belle R. and Joseph H. Braun Fund. The series is an annual event on a topic of vital interest to the legal profession and to legal education. Joseph Braun graduated from John Marshall Law School in 1918. He served in a number of positions of distinction within the legal community until his death in January 1989 at the age of 92. Much of his legal career was devoted to legislative issues involving motorists. Throughout his career, he evidenced the highest standards of professionalism and integrity. Following Judge Webster's speech, I will introduce you to a distinguished group of panelists for their comments. After the panel discussion, there will be opportunities for questions from the audience. And then shortly after 4 o'clock, we'll adjourn, and there will be a reception on the third floor of this building. William Webster was born in 1924 in St. Louis, Missouri, and received his early education in Webster Groves near St. Louis. He was awarded a Bachelor of Arts degree from Amherst College in Massachusetts. He received his Juris Doctor degree from Washington University Law School, St. Louis, Missouri in 1949, where he was elected to the Order of the Coif. He served as a lieutenant in the U.S. Navy in World War II and again in the Korean War. A practicing attorney with a St. Louis law firm from 1949 to 1959, Judge Webster served as U.S. Attorney for the Eastern District of Missouri from 1960 to 1961. He returned to private practice in 1961. From 1964 to 1969, he was a member of the Missouri Board of Law Examiners. In 1970, Judge Webster was appointed a judge of the U.S. District Court for the Eastern District of Missouri. And in 1973, he was elevated to the U.S. Court of Appeals for the Eighth Circuit. He resigned in February of 1978 to become director of the Federal Bureau of Investigation. In 1987, a newspaper article commented that Judge Webster was not J. Edgar Hoover. Judge Webster was not J. Edgar Hoover. But apparently I would hope that he would have had more control over sound systems than I do. The article stated that it was partly because Judge Webster had resisted so many of the temptations of the power that came with the territory, that he commanded the respect of Congress, which at that time, in 1987, was called upon to ratify his appointment as director of the Central Intelligence Agency. And he served as director of the CIA until 1991. Judge Webster served as chairman of the Corporation, Banking, and Business Law section of the American Bar Association and as a fellow of the American Bar Association. Over the years, he has received various awards from all different kinds of organizations. And in 1991, he was presented the Distinguished Intelligence Medal, and later in 1991, he was awarded the Presidential Medal of Freedom and the National Security Medal. He holds honorary degrees from numerous schools. Judge Webster was married to the late Drusilla Lane Webster. He's the father of 3 children, Drusilla L. Bush, William H. Jr., and Catherine H. Rossel, and has 7 grandchildren. On October 20th, On October 20th, 1990, Judge Webster married Linda Clugstone, who is present here today. At the time Judge Webster left the FBI in 1987, he was coming to the end of the maximum term of 10 years, something I hadn't known about. In 1976, Congress passed a law limiting the term of the FBI director to 10 years, having had the experience of having J. Edgar Hoover for about 50 years. After the death of William Casey, Judge Webster was nominated as director of the CIA in 1987. Judge Webster, known for his honesty, integrity, and good relations with Congress, was given the assignment of restoring the CIA's image, which had been badly tarnished in the wake of the Iran-Contra scandal. In contrast to the style of his controversial predecessor, William Casey, Judge Webster ordered a review of all secret activities conducted by the CIA. Insiders say that Webster asked some tough questions and demanded legal justification of every covert action before the fact rather than after. Said a congressional aide, he's very lawyerly, which is one of the reasons we have fewer differences today. It is my honor and privilege to welcome as our second annual Braun Distinguished Lecturer, the Honorable William H. Webster, whose topic will be the rule of law in an emerging new world. Judge Webster.
Thank you very much, Professor Domsky. Can you hear me all right? Good. I'm very pleased to be here and to share some thoughts with you. Chicago is always an interesting and challenging place. You survived the Great Fire. You are coping with the Great Flood. And here in the Windy City, surely you can put up with a little wind this afternoon. I received a lovely letter from Dean Markey telling me that I was about to be invited to deliver the Braun Lecture and urging me, if at all possible, to do so. Howard Markey and I have been friends for many years. He sat on the 8th Circuit when I was there, and he is a tough man to say no to. I had just joined Milbank Tweed and was busy trying to reestablish myself as a lawyer. So I took the invitation under submission. A few weeks later, this time from Judge Markey, I got a call saying, "Have you made up your mind?" I said, "Give me a little more time." A few weeks later, I got a call from General Markey saying, "It's time." I said, "I'll come." And I'm delighted that I did so. Delighted for a number of reasons, not the least of which is the pleasure of visiting again with my old friend, Judge Aldersert, who is here as your judge in residence this week. We will go back as far as I go back in the judiciary 20 years ago. One of the great minds and one of the most intellectually alive judges that has been my pleasure to know over the years. And I might also say that I'm pleased to see that my former special assistant at the CIA dropped by to hear what was going on. Neil Wolin, will you stand up? I'd like to introduce you. Neil is home is in Chicago, and he did a superb job keeping me on the straight and narrow line, which was one of his tasks, to wander through the agency, ask the hard questions, give me as much insight as I could as to what was going on, truly arms and legs that were indispensable to me. Finally, I probably should introduce my wife, since she was born in Macomb, Illinois, and considers this her home state, Linda. And finally, I should say that I have, for over 20 years, chaired a similar lecture in St. Louis at Washington University called the Tyrrell Williams Lecture. I know the importance of such a single lecture to a law school. the opportunity to share ideas with students and faculty alike, and I am all the more complimented and honored to have been given this opportunity to speak today. I thought that I would talk to you about the emerging New World Order that we have heard so much about, although perhaps a little less lately in the heat of a political campaign, but particularly the rule of law in an emerging world order, the subtopic of which is through a glass darkly. The rule of law are magic words for lawyers steeped in Anglo-Saxon jurisprudence and tradition. The great documents proclaim the supremacy of law over individual authority. We say we are a government of laws and not of men. In the penumbra of this concept are individual rights, sometimes expanded in international terms to human rights. The Magna Carta subjected the monarch to the rule of law, pointing the way to constitutional monarchy, the precursor to modern democracy. Indeed, democracy as we know it has as its core value the rule of law. We find it in the Declaration of Independence. We hold these truths to be self-evident. In the Constitution and in Bill of Rights, we the people. And in the defining statements such as the Gettysburg Address, all men are created equal. We take it for granted that our leaders act with authority, including the authority to make laws, because the people have given them that power. I think it's interesting to note that under the old Soviet Constitution, the government and the party granted rights to individuals, the opposite of how we think about the origin of power in government. And so I ask the question, is it therefore fair to assume that all the emerging democracies think as we do about this important subject? Or even more important, that they act as we like to think that we do under the rule of law? I'm not so sure. I'm not so sure that the rule of law means as much to vast numbers of people throughout the world. They come from different environments. They live under different traditions. There are different degrees of stability. And I think of de Tocqueville's comment quoted by George Kennan in trying to explain the Soviet Union in 1951 about how he is more and more convinced that the kind of government that emerges from a society is a reflection of their cultures and their traditions. And that may give us an indication of the difficulties and the challenges ahead, particularly in the Soviet Union, where for 1,000 years the people in that empire have been subjugated to an absolute form of authority. And so democracy will necessarily be, for them, an acquired taste. I think of other differences in perception. For example, our grand jury system, enshrined in our Constitution, is largely unknown or unused outside the United States. I recall in 1960, when I was a United States Attorney in St. Louis, hosting a group of Ecuadorian law students who came by to see me and to learn about how we do business. I had a grand jury in session, and I was just about to return indictments to the district court as they arrived. And so I said, would you like to come down to the courtroom and see me return these indictments? And they thought they would, always talking through interpreters. We went down and we went through the formality of presenting the indictments to the judge. The judge entered the appropriate orders. And then he said, would any of you have any questions you'd like to ask me? And one of them stood up and through an interpreter said, yes, if you have already found him guilty Why are you trying him all over again? A reflection of different cultures and traditions that we have to take into account in assessing our common march toward a rule of law. Out of my own observations, I have come to one unshakable conviction, and that is that it is fundamental that the rule of law cannot function in countries which cannot protect their judges and their justice officials. In Colombia, for example, a minister of justice was assassinated. The Supreme Court came under artillery fire, and many justices were killed. Judicial strikes were threatened. A reformist minister of justice was intimidated out of office. Extradition laws have been repealed to mollify drug lords. Colombia has been a crown jewel in democratic reform in Latin America, but it cannot succeed if the judges are afraid to do justice. In Haiti, we have seen the irony of a Supreme Court justice elected by the Haitian Parliament literally under the guns of the army. In Italy, the government undertook to try leading members of the mafioso in Sicily, and it was necessary to construct a fortress to protect the judges from physical attack. The magistrates lived in a compound for over a year, and this called for major sacrifices and great courage, not readily found in many parts of the world. After years of investigations and maneuverings, it appeared that the murderers of religious volunteers and educators in El Salvador would finally be brought to justice. And then we read that the judge planned himself to flee the country after the sentencing. I think we can all understand his concern, but what kind of a signal did that send about El Salvador? I think our country, for a lot of reasons, has a much better tradition for protecting its judges. I recall how one of the judges from my old court on assignment to Little Rock used to walk at night unattended when he was trying cases arising out of Braun versus Board of Education, a very intense period in our history. The risk is a bit greater today, but nothing like in the countries that I have been describing to you. Moreover, we have demonstrated our resoluteness to bring to justice all those who injure or threaten our judges. When Judge John Wood of San Antonio was shot to death in San Antonio, he was the first federal judge to be assassinated in this century. There were no eyewitnesses and no crime scene evidence pointing to a suspect, although logic pointed to a group of drug dealers, one of whom was up for sentencing by Judge Wood. It was a case that simply had to be solved. I was director of the FBI at the time. I visited the scene with agents and officials, and I supported every effort to bring this case to solution. Several 100,000 bits of information were entered into dedicated FBI computers. Informants were developed. Court-authorized electronic surveillance of suspects in penitentiaries produced more information. And finally, the case was cracked. Incidentally, the judge who tried the case, William Sessions, is now himself director of the FBI. It took 3 years. In very few cases worldwide could such an effort have been marshaled to bring the assassins to justice. In very few countries would there have been the same resolve. The United States has provided training and forensic expertise in San Salvador, created a Caribbean training center, and even sent special FBI teams into the Virgin Islands when local murders were getting out of hand and went beyond local capability. The National Academy annually trains several foreign law enforcement officers, but this is a small part of the solution. Full justice will not be done as long as those to whom it is entrusted live in fear for their safety and the safety of their families. Very often the quality of justice is measured by the rational nature of punishment, the degree and the impartiality with which it is imposed. In our own society, there's much talk these days about the sentencing guidelines, particularly the new ones, considering offenses by corporations and officers. Yet in far-off places in the world, the concern is whether similar procedures and punishments should be replaced by fundamentalism, Islamic law, for example, with its severity and its harsh views of the woman's place. A few months ago, I watched on television as an American mother argued that her son should not be subjected to a Pakistani court-imposed sentence for bank robbery, removal of one hand and one foot. Fortunately, because of public protests, the court found the evidence insufficient and let the boys come home. And in India, very recently, vigilante groups frustrated by government inaction were permitted to capture, try, and convict those suspected of crimes and thereafter tie them in the sun to a rack in public disgrace. We must also recognize that the judicial process in some areas can be a facade, only adding to disillusionment and disorder. Liberia had a constitution almost word for word from our own. They flew a flag derived from our flag. We helped to settle Liberia, but not in practice. When I arrived in Monrovia 3 years ago, I was scheduled for an 8 p.m. meeting with the Liberian National Security Council. I was informed matter-of-factly that the Minister of Defense would not be presiding as he usually did because he had just been arrested in connection with a ritual killing. A head had been found in his backyard. The Minister of Justice, who lived 10 years in Detroit, told me that civil rights were counterproductive in a country like his. When I was in South Korea in 1986, the then president was concerned for his safety, and as we got up from lunch at the Korean Blue House, he wanted to know what we did to protect our former presidents. And then he said that in emerging democracies, too many people equated liberty with license, and that it had to be controlled. Well, of course, we're all familiar with Edmund Burke's concept of liberty with order. We call it ordered liberty. But in many countries, order transcends any cultivation of liberty, which is feared. We have only to remember Tiananmen Square. Only last week in this hemisphere, democracy received a setback when President Fujimori of Peru dissolved the legislature and the judiciary and suspended all parts of the Peruvian constitution inconsistent with his actions. The OAS has protested. His only excuse was fear of the shining path, the Sendero Luminoso, and it was a vote for order rather than the rule of law. I must say parenthetically that before we are too righteously indignant, it's well to remember that Abraham Lincoln suspended the writ of habeas corpus in 1861 or 1862, and remember what Margaret Chase Smith, the great senator from Maine, said on the floor of the Senate in the dark days of the 1960s, that given a choice between repression and anarchy, Americans would reluctantly choose repression. In the Soviet Union, before its dissolution, we saw some major moves toward the rule of law. Gorbachev spoke of it constantly. His concept, however, was somewhat different. It was the rule by law, the duty to follow the laws on the books until changed. It lacks the majesty of the rule of law, but it is a step in the right direction. Time will tell how the Commonwealth of Independent States will emerge. They still struggle to define rights under law within the context of their own separate cultures. But the judiciary is not yet independent, And until it is, they will continue to have telephone justice, and the law will not be seen as supreme. There's new hope in the Eastern European countries which are reaching out to us for help. I think particularly of the assistance that our bar and our State Department have provided in framing a constitution for Czechoslovakia and in assisting in privatization there and elsewhere in Eastern Europe and the Baltics. And this is an important contribution. One of the most encouraging initiatives has come through the Conference on Security and Cooperation in Europe. We call it CSCE, which in 1990 sponsored what has become known as the Copenhagen Document. Representatives of 35 states, including the United States and the former Soviet Union, joined in approving an important statement about the human dimension. Let me read just a few lines from this document, which could have real impact if appropriately implemented by the participating countries. It said in stating their purpose, they said they recognize that pluralistic democracy and the rule of law are essential for ensuring respect for all human rights and fundamental freedoms. Again, they wrote, the participating states express their conviction that full respect for human rights and fundamental freedoms and the development of societies based on pluralistic democracy and the rule of law are prerequisites for progress in setting up a lasting order for peace. And they said they are determined to support and advance those principles of justice which form the basis of the rule of law. They consider that the rule of law does not mean merely a formal legality, which assures regularity and consistency in the achievement and enforcement of democratic order, but justice based on the recognition and full acceptance of the supreme value of the human personality and guaranteed by institutions providing a framework for its fullest expression. That's our view of the rule of law. And they reaffirm that democracy is an inherent element of the rule of law. They recognize the importance of pluralism with regard to political organizations. And then they said that they solemnly declare that among the elements of justice, which are essential to the full expression of the inherent dignity of the equal, or of the inherent dignity and of the equal and inalienable rights of all human beings, are the following. I mention only two of several. The duty of the government and public authorities to comply with the Constitution and to act in a manner consistent with law. And what is important to me and the main focal point of my remarks to you this afternoon, the independence of judges and the impartial operation of the public judicial service will be ensured. This is really quite an important commitment, and one which, if carried out, holds great promise for the future. Well, finally, the world has turned away from communism. It has failed. And as we move to assist emerging democracies in economic and political matters, it is important and vital, in fact, that we devote substantial energy and resources to helping them mature and to nurture, care for, and feed that core root of democracy, the rule of law, and with it, an independent judiciary. The alternatives to failure are likely to be anarchy or repression, not communism, anarchy or repression, as desperate people turn from law to despots to restore order. There is, I believe, a hunger in the world for what we preach but do not always practice. Translations of the Federalist Papers are being widely read in the Russian republics. The internationalism of the rule of law is an important beginning. But we must search for ways to safeguard the integrity of the judicial process in countries where corruption and co-option have too long dominated the landscape. there is hope. It is not too simplistic to observe that public resistance at the time of the attempted coup in the Soviet Union was not for love of Gorbachev personally, but for outrage that the promise of democracy under law had been so crudely challenged. The spirit of liberty that learned Hand so eloquently described must live in the hearts of men and women in countries deprived of freedom for countless years. If we do our part, the lawyers of those countries may yet say with learned Hand, descended to us in some part molded by our hands, passed on to succeeding generations with reverence and with pride. We at once its servants and its masters renew our fealty to the law. Thank you.
Thank you very much, Judge Webster. As you can see, we have assembled a very distinguished group of panelists, truly international, who have been selected for their expertise in international law. In alphabetical order, our first panelist is Professor Igor and Graussen. At the present time, Professor Graussen is a faculty fellow at the Kellogg Institute for International Studies at the University of Notre Dame. Prior to that, he served for 2 years as a distinguished professor of legal ethics at the Notre Dame Law School. He has taught various subjects, including comparative constitutional law, the USA and the USSR, recognition in public international law, Soviet business law, and introduction to classical Roman law. He's published several books in Russian and Estonian, and written several student manuals. He has published 47 articles in Russian on various legal subjects, and also, you'll be happy to know, he also speaks English. He's also authored several articles in English, including reflections on the philosophy of law, constitutional development in Estonia, and the international recognition of national rights, the Baltic States case, all published in the Notre Dame Law Review. As you might imagine, he was educated in the Soviet Union. He is a graduate of Tartu University Law School in 1975. He received a PhD in law at the All-Union Institute of Law in Moscow in 1979. In 1987, he received a Doctor of Sciences in Jurisprudence at the Moscow Institute of State and Law. And in 1988, he was made a professor of philosophy of law. He was a member of the Supreme Soviet of the USSR, and he helped draft the Constitution of Estonia. Our second panelist is Belle Ikomi Ngangi. Professor Ngangi is a native of Cameroon. He has traveled extensively in Africa, Europe, North America, and the Caribbean region. He's fluent in English, French, 3 African languages, and admits to speaking halting Spanish. He is presently a visiting professor at the University of Puerto Rico School of Law, and is also currently doing research at Harvard University, and is also teaching as an adjunct at Brandeis University. He's authored various articles about the Cameroon and international legal issues. He's helped draft legislation for his native Cameroon, and he practiced law in Cameroon, both in private practice, and also he practiced law for National Hydrocarbons Corporation. He received a Bachelor of Laws from the University of Lagos in Nigeria in 1978 with honors. In 1979, he was awarded a Barrister at Law degree and practical training in law in Lagos, Nigeria. In 1982, he was awarded his Master of Law degree cum laude from the University of Brussels Law School in Belgium. In 1988, he received a Certificate of Orientation in the United States legal system from Georgetown University Law Center. In 1991, he was awarded a Master of Laws degree from Harvard University Law School. And our third panelist is Professor Paul Brooke Stephen III. Professor Stephen is the Percy Braun Jr. Professor of Law at the University of Virginia School of Law in Charlottesville, Virginia. Professor Stephen has taught courses in federal income taxation, corporate taxation, estate and gift taxation, international taxation, tax policy, all of which are warm to my heart, but also contracts, Soviet legal system, research seminar in Soviet law, tutorial in Soviet law, international business transactions, Soviet capitalist business transactions. That's sort of an oxymoron. Soviet capitalist business transactions, international civil litigation, U.S. Supreme Court decisions, and legal aspects of foreign intelligence. He's published extensively both in the tax area and in the international law area. He is also the author of several books. After graduating from Yale University cum laude in 1973 with a Bachelor of Arts degree, he received a Master's of Arts in Russian Studies at Yale in 1974. In 1977, he graduated from the University of Virginia School of Law, where he was the executive editor of the Virginia Law Review and was elected to the Order of the Coif. After clerking for Judge Levin H. Campbell of the U.S. Court of Appeals of the First Circuit, Professor Stephen then clerked for Lewis F. Powell, Jr. of the Supreme Court. He has held various academic positions at the University of Virginia Law School since 1979. The moderator for our panel discussion, who was also instrumental in bringing all three panelists here, is our very own Professor William Mock, Jr., who is a professor of law at the John Marshall Law School. Bill Mock received his BA at Haverford College, did graduate work in England, I think he practices English there, and obtained his Doctor of Jurisprudence at Georgetown University Law Center. Prior to entering academic life, Professor Mock practiced international trade, antitrust, and securities law in Washington, D.C. He also worked at Baker & McKenzie on a pilot project to develop training programs and materials for other lawyers within that primarily international firm. He's taught a variety of courses here at John Marshall Law School, not only in the international area and securities area, but also corporation law and wills and trusts. He's presently the director of the International Law Program here at John Marshall Law School. He speaks regularly on international subjects and has published law review articles on trade with Eastern Bloc countries, terrorism, and import regulation. He is our faculty advisor to the International Law Society and to the Jessup International Law Moot Court team. Professor Mock will explain to you what the format for our panel discussion will be. Professor Mock.
After that introduction, I'm not sure whether to speak in English or American. I'm relatively fluent in both, though, so I'll do my best. After this fine presentation by Judge Webster, what we're going to do is have a brief presentation on related matters from each of our panelists, raising issues and responding to issues brought up by Judge Webster. I've encouraged the panelists to respond to each other in a way that will produce something of a dialogue, and to ask questions of each other as is appropriate under the circumstances. Once each of them has given a presentation, I will give them opportunities to respond to each other if direct questions have been raised, and time permitting, and I trust it will be, to throw the questioning period open to the floor. We would encourage you to address these gentlemen with your questions on the topic of the day. The presentation by Judge Webster is of particular relevance and importance today, largely because of the timely demise of communism in Europe and the Soviet Union, or the former Soviet Union. It is precisely the states that have emerged from that communist past that present the most immediate and obvious challenge to the development of the rule of law in today's nations. The countries that have either emerged or re-emerged from that context are faced with a problem of either establishing the rule of law for the first time in their histories, or of re-establishing it for some of the countries that had a liberal democratic regime prior to the communist takeovers. Professor Graussen, as a prominent academic, was an observer in Estonia and the Soviet Union itself during the period of the collapse of communism, and indeed played something of a role in it because of his participation as a People's Deputy from Estonia to the Soviet Congress of People's Deputies. And I will call upon him first to present his views on the development of the rule of law in that context.
Thank you. Dean Chairman. Oh. Okay. Mr. Chairman, ladies and gentlemen, Your Honor, there was a cartoon in one comic magazine in Estonia about 2 years ago, you know. A hound and a fox were sitting under the tree and having little drinks, and then the hound explained to the fox, you know, buddy, I'm not such a bad guy at all, but it's my job. So, sorry, it's my job. It's a panelist's job to challenge the author of a main presentation. I'm happy to know that we share most of the all principal professionals' human and ethical values, but really I'll try to contribute simply by adding something to what has been said, to highlight some moments that I think need certain further discussion. On the 13th of December in 1990 in Moscow in the Congress Hall, we, the Commission of Drafting the Soviet Law on Constitutional Supervision, was sitting in a smoking lounge and discussing really final version of that law. And about 2:15, 2:16, Mikhail Gorbachev came in, and he insisted that the times for discussions are over, constitutional supervision must be implemented immediately, or something like that. So you are all these educated professors here, enough is enough, so the law must be ready in 1 hour. And the law was ready, of course. But what we started to think after Gorbachev rushed out again, we started to think, what will happen if we establish a very good system to supervise, to control, to implement bad law? If there will be a strong, efficient body with the functions very similar to American Supreme Court in constitutional branch of its activities, if there will be such a strong body that will really one day implement that Soviet constitution. Why we survived? Because Soviet constitution in reality was never implemented, thanks God. So the question is rule of law, and I want to emphasize what was made so clear by Judge Webster. We must always ask, which law? The rule of which law? We must not forget that Hitler's power in Germany was perfectly legal. Hitler won through perfectly democratic elections. And we know the results. On the contrary, let's think back into glorious history of this great nation and country. Well, Declaration of Independence was clearly highly criminal act. And that's why after signing Declaration of Independence, the authors preferred to leave Philadelphia immediately because they had committed a high treason. we repeated the same practice after we declared sovereignty of Estonia. I rushed back to Tartu and after that to Moscow, just in case. So the question remains, what is the nature of the law that has to be implemented? And that's why I want to point at one moment that was mentioned several times during Judge Webster's presentation. The rule of law, yes. The rule of law is a great value, yes. But this is not always, and in very many cases, it is not the rule of positive law. This is the rule of higher law called natural, God-given, supreme, whatever law. And that law must prevail. Today is one of the last days of 6th Congress of People's Deputies of Russia. And there is an eternal contradiction between conservatism and democracy, communism and liberalism, not in American, in European sense of the word. By the way, when Bill Mock said that there were liberal democratic societies in certain parts of the former Soviet Union, no, they were normally democratic societies. They were not liberal democratic societies. So, now the question, the challenge for Yeltsin today is, he has Communist Congress there, who tries to pass, and sometimes even successfully passes, the laws aimed at preservation of the existing system. And now there is Yeltsin, who has the right, fortunately, who has the right to rule by executive decree, and executive decree, by its legal modality, is not law. It's administrative order. And finally, we may say that every administrative order is an act of discretion. This is not rule of law. What is now more important? Executive discretion of Boris Yeltsin and his government, or the rule of law made by communist, very communist, semi-communist, and semi-liberal Russian parliament? I am not legal advisor to Yeltsin, but I worked with him all these 2 years in Moscow. And if once I'll meet him again, I think that one day I have to ask him whether it would not be wiser to get rid of this parliament, imposing this rule of law. Wouldn't it be wiser to call for new elections? Or even if that is not possible, to rule almost alone, because we know what the Yeltsin and his team are, because they are for democracy. And on the contrary, our beloved Mikhail Sergeyevich Gorbachev, tens of laws, lots of legal rhetoric, and of course his insistence upon the rule of law. The rule of law for whom? Why? By whom? For the same communists? For the same small elite group? And that was it. So I think that this moment, emphasized by the human dimension of the rule of law, is intellectually, morally, ethically, legally, theoretically, the most important one. And I want to emphasize this aspect of Judge Webster's speech. Not mere rule of law, but the rule of higher, natural, God-given law. And if you don't mind, let me make one or two comments on a couple of details, so my main presentation is over. It is a traditional view that Russia does not democratic traditions. It may sound as a surprise, but since 1861, if we compare the independent Russian judiciary with the independence of American judiciary, I really do not know which one of these two were more independent. It may sound strange, but if we go case after case, then we can say that, yes, American judiciary was fairly independent. The really independent judiciary was in Russia. How this could happen? There was a monarch, there were no parliament, there were no constitution, nothing. How this could happen? And now the question is, what rule stood behind the Russian Tsars? They were not bloody guys running with their swords on the street and killing people to the right and to the left. Why? Because even the worst, the most conservative Russian Tsar, Alexander III, and all the others, they understood that they govern thanks to the Lord's law. And there is ethical higher responsibility. Thank you.
I have a map in my office that I bought, 6 months or a year ago. It's already out of date. For one thing, it fails to show Professor Graussen's country. It shows it instead as a small lump in the upper left-hand side of the Soviet Union, which it is far from being. The last major wave of development of nation-states in the world emerged during the 1960s, when the colonial powers of the world abandoned or left or were stripped of their control over much of the world. And indeed, I grew up having to relearn Africa during that period. The world has palpably failed in its attempt to establish the rule of law uniformly across Africa. We talk today of the establishment of the rule of law in Eastern Europe and the former Soviet Union, as though it were a project that was something we can all put ourselves together and accomplish, and yet we have the failed example of world effort in Africa. Indeed, we see the rule of law for the elite minority, as described by Professor Graussen, as the standard rather than the exception in much of Africa. There is furthermore a risk that during today's very exciting development in Eastern Europe and Soviet Union, and the hopes for the collapse of communism in the few countries where it actually still holds some sway, that we will forget the countries that have been struggling for many years. And I've asked Professor Ngongi to address this aspect, the historical aspect of today's current issues.
Thank you very much, Bill. I must confess to a prejudice that I harbored before I came here and listened to Judge Webster talk. As one who has historically followed the involvement of the CIA in most developing countries in the world, especially Africa, I had grown up to know that the CIA had developed a notorious reputation for destabilizing many prominent regimes that would have come up in replacement of the oppressive regimes that were instituted by the former colonial masters of many of these countries. The pleasant surprise I got this afternoon actually was the fact that Judge Webster represented in his speech a complete opposite of what I had imagined would come from one who had represented such an institution. And I feel very humbled by that fact, that as one who has been a champion of fighting against prejudice, I had become a victim of that. Furthermore, one of the issues that has struck me more particularly is the fact that Judge Webster presented in very, very clear terms a theoretical basis for the re-examination of the situation in the world. But one problem I do have about his presentation, and that's the question I do ask, is how do we get to translate theory into practice? For is it the theory that has been lacking in the past many years, or is it the practice of this theory? Have people, lawyers, academics, not been aware of the rule of law? And has the rule of law not been preached sufficiently in law schools and academia and other aspects of national or international activity? The question I do ask actually is, how has the rule of law not been applied uniformly around the world? And how has the absence of this practical application affected detrimentally the lives of millions of unwary people? I'll go a step further, and I will, with very much due respect, agree the fact that the issue of the rule of law really is not the issue, but it's an issue of a higher law, as both Judge Webster and Igor brought out. It's an issue of justice. May it be social justice, economic justice, political justice, moral justice, cultural justice. Has law actually brought about justice in the world? And if the law has been used as an instrument of ruling the world, how has it been used? By these same champions of law, champions of the rule of law. If it has not brought about the justice we do seek, is there any amount of credibility that can be given to law? These are questions that I have grappled with for many, many years. Unfortunately, I have not come by any answer yet. What does law exist for if it does not serve the human cause? Law was used in the 1884 Berlin Conference, which brought about the haphazard demarcation of Africa. Law was used to justify slavery, which resulted in the tremendous dislocation of many otherwise prominent kingdoms in Africa, and the humiliation, the unknown humiliation of millions and millions of people. Law has been used to justify apartheid. We have known that all has been done under the rule of law. But has this rule of law really addressed issues of justice? Looking at the issue about the emerging New World Order, what is this New World Order we talk about? Does it presume that the old world order has been replaced? Or what was the old world order? If we do assume that a new world order is emerging, how different is it from the old world order? And what did bring about it? Is it the process of law? These are questions which I've had the privilege of discussing with some of people in high places in the Western world who are involved in shaping this supposedly new world order. It brings me to a discussion I had 2 weeks ago, a very privileged discussion I had for a high member, civil servant at the Department of State in Washington, D.C. I was very graciously invited to have lunch with him and a number of people from his staff. And before I got to this meeting, I tried to procure a copy of the Human Rights Report prepared by the Department of State on Cameroon, the country I come from. For those of you who don't know much about Cameroon, Cameroon supposedly gained its independence in 1960 and 61 respectively. It has had the unfortunate experience of having gone through 3 colonial legacies. First the Germans, and then after the First World War, it became a trust territory divided in 2 unequal parts between the French and the British. Upon independence, the president who was imposed upon Cameroonians was imposed by the French. And like Bill did very well point out, the choice of leaders of Africa in the post-colonial era was very carefully predicated upon the allegiance of these leaders to the former colonial masters. In other words, the same Western democracies which had perpetuated the process of colonialism did produce a system whereby leaders in those countries were repressive upon their own people. And the unfortunate result of this was that those emerging young leaders who fought against the system were branded as communists, revolutionaries, or activists, or whatever. And we know in history that many of them died mysterious deaths. Some of them which unfortunately were associated with activities of the CIA or the KGB. And this is where we come to the issue I want to raise here. For long, the African continent, among many other so-called developing countries, were the playground of the big superpowers of the world, namely the former USSR and the USA, and nominally by other European countries. The rationale for the presence and the interference with the internal policies of these countries and the propping up of otherwise unacceptable regimes within international standards was that it was staving up, in one sense, the influx and the influence of communism, and in the other sense, the influence and influx of capitalism, depending upon whom you were talking about. Well, we have noticed the demise of the communism, that big evildoer in the world. Has that really brought about change? Has that brought about the change we talk about in this so-called New World Order? When I read through the Human Rights Report on my country, Cameroon, incidentally, I happened to be in the US because I cannot live in Cameroon under the present regime, which I actively oppose. I did read there very clearly that there have been hundreds of unjustified and unaccounted killings, all kinds of forms of brutality, some of which I had witnessed. I had suffered 3 attempts on my life myself before I ran out of the country. And most of these things that were documented in the report were true. But I was faced with a very interesting situation when I asked this gentleman at the Department of State, what is the US, as a champion of democracy and the rule of law, doing to ensure that the rule of law, in whatever form, which will produce justice and a democratically elected leadership, was brought about in Africa and several other developing countries, which at a certain time in history were playgrounds for the superpowers. Now the superpowers don't have anything to play about anymore. They're no threats from the Soviet Union. What justification is there? Well, but the answer I got was that actually things have improved in Cameroon, you know. Well, the perception we do have in Africa, and this is the issue, people in these countries are not really allowed to partake in the decision-making of their countries outside of the repressive governments with which Western democracies have official links with. And the perception that we do have is that at a point in time we are ready to go through the deprivations of the absence of aid, which will result in the demise of these repressive regimes. Now, the perception that we do get now is that these repressive regimes are being propped up by the same Western democracies which preach democracy in our countries through the different forms of economic, political, and military assistance they do get. When this gentleman told me that actually things had improved tremendously in Africa, particularly in Cameroon, it raised the issue in my mind of whether there were certain double standards of human rights law in the world, or whether there were a universal standard. So I asked him, "Sir, you have read the human rights report I have read. Will this situation, to your mind, be acceptable to the people of your country, the US? Will that be a minimum standard that can be accepted as agreeable?" Well, I haven't had an answer 2 weeks later. But I guess we all can understand what answer you will have. Certainly, human rights violations are not accepted in this country, although we know they do exist. But in our countries, although we know they do exist, they are encouraged by people we do expect to help us get rid of them. And how are they encouraged? Through the rule of law. As we face this challenge of an emerging new world order, several questions come to mind. How do we support the international institutions upon which we're supposed to depend to really bring about an international new world order? Because a world order presupposes the internationalization of law. It doesn't presuppose the usage of Soviet law or American law or Egyptian law. But while we do recognize that the interpretation of rule of law differs from civilization to civilization, from culture to culture, one clear fact cannot be denied: that justice has no cultural, color, political, economic boundary. The people of Ethiopia who die of starvation love justice just as much as the people of Chicago who are suffering from the floods. Suffering has no color. Injustice transcends all forms of racial, economic, political barriers. Now, that is the kind of law we're talking about. And how are the champions of this rule of law perceived in the international arena? Are they really perceived as being honest, persistent, consistent, and constant in their championing of this rule of law? Or are they perceived as applying double standards? For what reasons? Self-interest? Today we see the channeling of efforts and energies towards the Eastern Bloc. The channeling of these efforts towards the Eastern Bloc certainly is not something bad. But the question we do ask, for 30 years and more, countries of Africa and Latin America and many other developing countries have been doing just what the Eastern Bloc is just beginning to do, trying to seek for themselves a free and just society. And what has been done? What has been done by the Western champions of democracy in the use of the rule of law to better the situations of millions of Africans today who die under the rule of law of regimes, oppressive, repressive regimes that are supported by the same democracies? In ending, I will just read a few lines from an article I picked up in Newsweek magazine of April 6, 1992. The title of the article is, in italics, emphasis, "This is a New World Order."
May I interrupt you?
Sir.
You dropped your voice. We wish to hear every word you utter, so speak right to the microphone.
I will, sir. Thank you very much. The title of this article in the Newsweek magazine is, "This is a New World Order?" ? And they go on to say, "The rejuvenated United Nations tries to salvage Somalia." We know about Somalia among many other countries. The beginning, I'll read a few lines to say, "Poor Somalia. First a battleground for the Cold War, now a testing ground for the New World Order. And then they go on later in the article and say, sovereignty cannot exist without law and order. That is why we asked the United Nations to bring peacekeeping troops, not only to divide our forces, but to disarm the civilian population. They have a very armed civilian militia. And they go on to say, many Somalis starving or caught in the crossfire also are looking to the rejuvenated United Nations to somehow rescue what remains of their country. But they say, Washington funds 30% of United Nations peacekeeping operations. And the US political climate right now hardly encourages any further spending on faraway lands. But we all know the influence of the United States in world affairs. It's not a negligible influence. We all know how much change can come about by the positive role of United States intervention in many situations in this world. And we are aware of what has happened in the past, Iraq, Kuwait, and in a lot of other places. The question I ask, will it be a different rule of law? Will it be a different standard of human rights? Or will it be a different set of interests that will propel the US and many other Western democracies to ensure that the struggle that has been going on for 3 decades and more in the African continent and in many other developing countries outside the former Soviet bloc? I will ask that again. What will it take the countries of the Western democracies not only to recognize and acknowledge and assist the efforts, the unyielding efforts that have gone unrecognized for more than 3 decades in Africa and other developing countries, outside of the expression of their personal and individual interests? Will it be the rule of law? Thank you, ladies and gentlemen.
We have thus far spent time focusing on the development of law within nations, with, we hope, the encouragement of the United States and other Western nations where the rule of law, but not always what law, is relatively well established. Professor Paul Stephen has been studying the rule of law both within nations and in relations between nations for many years. As a scholar of national security issues, Professor Stephen is well aware of the trade-offs between the rule of law and issues of geopolitics and national security, issues raised by Professor Ngongi. As a scholar of legal developments in the former Soviet Union, he's also aware of the challenges faced in the development of the rule of law in these new and interesting and developing countries of that region. I've asked him as our final speaker to deal with both these threads of our presentations today. Professor Stephen.
Thank you, Bill. It strikes me in listening to the presentations, the excellent presentations we've heard this afternoon, that we are seeing to some extent a testing of the limits of the concept of rule of law, what it means. Judge Webster began by pointing out quite correctly, I think, that this is a different concept than rule by law. In Russian, the Pravovina Gosударство, or law-based state, in German, the Rechtsstaat, really is something quite different than what we mean by rule of law. Professor Graussen pointed out that simply the rule of law without any concern about the moral content of law too easily led to the kind of mindless positivism and even the evil banality of Nazism. And he might have said, I know he would have included the Soviet state as another example of that. And Professor Ngonge, I think, quite forcefully asked us to engage in the notion of the relationship between law and justice. So in some sense, we have to come to grips with the meaning of the term itself. I'll offer a suggestion for what it's worth. And for me, the suggestion draws on my fascination with the concept of paradox itself. It seems to me that any decent, civilized, law-based society has to come to grips with a very fundamental paradox. The paradox, I believe, is this, that on the one hand, without an underlying sense of justice, decency, and morality, human existence is meaningless and ugly and degrading. On the other hand, a monolithic, rigid, uncompromising notion of morality, one that admits no challenge, has been throughout human history the excuse for some of the grossest barbarisms ever inflicted on humans. So the paradox, morality is essential, too much morality is fatal. How to resolve that, I don't have any clear answers, but I have some thoughts, and I would like to relate these thoughts not just to Judge Webster's presentation, but in a way, I think, to some of the more important public components of his career. Because to me, I think a saving grace of the notion of rule of law is the idea of dispersion of power under commonly recognized rules. Maybe not universally recognized rules, but at least commonly. And dispersion of power as opposed to concentration of power. The Nazis, after all, and the Stalinists as well, they announced their rules in advance, but there was no mechanism for challenging those rules. There was a complete concentration of power rather than dispersion. I look at Judge Webster's public career, and I mean particularly the two agencies that he headed, and I speak as someone who's followed both of those moments in his professional life very closely, with deep concern and with admiration. If I ask what were the contributions that Judge Webster brought to the two offices of head of the FBI and then later director of Central Intelligence, it seems to me that a fair case can be made for the claim that he brought both of those agencies back into a regime, maybe in the case of the CIA and the FBI, for the first time into a regime where authority and power was exercised in a way that was dispersed between the executive branch, his ultimate boss being the president, the judiciary, and Congress. That for too long both of those agencies had been under one head only and succeeded more in evading judicial and legislative control than cooperating with that. Judge Webster resolutely, and I think successfully, understood the notion that these powerful and necessary instruments of governance could exist in a civilized society only if there was shared control over them, that they had to honor the commands of the judiciary where they applied, particularly in the case of a police enforcement agency like the FBI, and he also respected very much the role of congressional oversight. He came to the CIA at a time when there was a deep crisis over a failure to honor the dictates of Congress with respect to certain critical areas. And I think he did a great deal to restore the notion that the CIA would operate effectively within the confines of a legislative system, not simply an agent of the executive branch. When I look more broadly at the notion of dispersion of power, to me, I think a central institution that allows law to be an instrument of the dispersion of power under rules that are commonly understood, something different from anarchy, is the notion of property. The notion of private property that is respected overtly and honored by the law. And I see this institution as having played and continuing to play an important role in promoting the rule of law, both in the public international order and in the domestic developments of individual countries. I will try and be brief and not too didactic. When I look at the public international institutions and the pursuit for some kind of better life, some notion of justice, as well as an idea of predictability of law, I look particularly at the success of the post-World War II economic international organizations. I think it's quite instructive to compare the track record of the IMF, the World Bank, and now the European Bank for Reconstruction and Development on the one hand, to the record of the United Nations. Not to belittle the shining ideals and important purpose that the United Nations brings, but to look at the actual implementation of those ideals in the world. I think it's hard to avoid the notion that the economic international agencies have had a more direct, profound impact on the process of development and what successes have been achieved, both in terms of economic justice and development of the rule of law. Indeed, watching the Congress of Deputies over the last few days, it struck me that the silent partner to those deliberations and the dialogue between the Yeltsin government and the Hezbollah legislature was a party not even represented, namely the International Monetary Fund. Because surely one of the things going on in the minds of the conservative Congress that was trying to rein in the ambitious reforming government of Yeltsin was, what would the IMF think about all this? Are we really willing to seize power for ourselves, cut off the reform process if it means once again isolating Russia from the international economic community and all that it holds out in the way of support and promise? When one looks at the development of countries on a domestic level, as opposed to in terms of a network of international organizations, surely central to what we call the collapse of communism and the growth of democracy in Eastern Europe and the Soviet Union is an effort to formalize and legalize private property relations. This part of the world has had a robust and important private economy for a long time, but it was not a law-based private economy. Indeed, it was an entirely criminal private economy. Surely part of the collapse of the regimes in those world was due to the contradictions between the public state-owned economy and the criminal system that it created and supported in the underground economy. And yet, for all the achievements of democracy and liberation, the fall of communism in this part of the world, what we really have not fully seen develop yet is a notion of property rights as something respected by law. The property institutions that have existed in this part of the world are based on possession and secrecy. I steal and I don't get caught. And out of that I exercise economic power, and that was essentially the nature of the economic power of the second economy. Converting that to a system where I own and I don't have to worry about my rights being stolen, violated, is an important cultural step still left to be taken, particularly in the former Soviet Union, but I think it's a problem that's confronted in Eastern Europe as well. And this, I think, brings us back to the role of the judiciary, which Judge Webster was talking about as well. So it seems to me that in the late 20th century, we in the United States are so aware of the enormous political achievements of our judiciary in terms of dealing with fundamental institutional questions. Braun versus Board of Education being the central, shining achievement of that judiciary, but we can think of other cases, United States versus Nixon I would offer as an example, that we seem to forget that the development of the American system of judicial independence and legal authority that we associate with more fundamental notions of justice, emerged out of property disputes. If we look at our landmark constitutional cases in our own history, most of these were more or less property disputes. Marbury versus Madison was about a job, after all. Gibbons versus Ogden, McCulloch versus Maryland, these were all regulatory issues where businesses were trying to get one form of government or another off its back. Please understand me, I realize I'm in downtown Chicago, not Hyde Park, and I'm not trying to make an impassioned plea for laissez-faire capitalism. All I am trying to argue is that within a system of ordered liberty, some role for private property is essential. Private property leads to the dispersion of authority, the dispersion of power. It prevents the concentration of power and the concentration of a relentless morality that can grind down everyone. And I think a system where private property is protected by law, that is to say by judges, is a system where judges are seen as the guarantors of rights that are not only fundamental, but that people can relate to on a day-by-day basis. I think the adjudication of private property disputes not only can lead to great constitutional moments, as occurred in early American history, but to a broader sense of the culture of judicial independence. If judges can be relied on to guard our property, then maybe we can also rely on them to guard our liberties and our sense of political freedom as well. Thank you very much.
Our three distinguished panelists have now reacted to the thoughtful presentation Judge Webster made of the importance of the rule of law and of an independent judiciary. And in doing so, they've raised a number of variations on the theme or different perspectives. From Professor Graussen's concern over what law, not just the rule of law itself, and the suggestion that natural law has an important role to play, not just simply the imposition of structure, but what is within that structure. Picked up in some ways by Professor Ngongi's suggestion that justice itself should be of greater concern, or of at least equal concern, to the procedures of the rule of law. Indeed, that you can never claim that the rule of law has reached its proper position in society unless justice itself has been served. Both of them pointing out examples between Hitler and slavery where the rule of law has been used for inappropriate ends. And Professor Stevens' argument that besides the rule of law there is something to the nature of property rights, not just jurisprudential norms that underlie any sense of an ordered society, and that those property rights are somehow tied or linked to the dispersal of power. If you spread the wealth far enough, I suppose, you're spreading the power and you're guaranteeing some sort of understanding of an ordered system. Okay. I'm certain that Judge Webster has listened carefully to these. I saw him writing notes constantly throughout these presentations, but he has suggested that perhaps an excellent way to bring a lot of these issues out would be to turn to you folks at this point and to see if some of you have questions or concerns that would allow us to develop these issues or related issues concerning the rule of law in the world today. Yes, in the back.
When you talk about concentration of wealth, is concentration of wealth the real rule of law that the country follows? The dispersal of wealth isn't more concentration of wealth, where you have the elite or you have the ruling class, if you will, concentrate their power and wealth. Is that the real rule of law?
The question involves, I take it, the idea that the concentration of wealth is the product of the rule of law in those nations? Is that?
I think application of the law.
Yeah, is the question that the rule of law serves the concentration of wealth? Is that the question? Is that your observation?
Well, this is brought up the fact that the dispersal of wealth and property is have more, a better rule of law. And I'm saying that the actual reality is most try to concentrate their wealth. And that becomes the rule of law. You concentrate your wealth, and then you become the ruler, or you become the lawmaker.
Paul?
I assume that was at least initially addressed to me, and I think that's a very fair question. My short answer, I guess, would be no, and then I would try and follow it up with an explanation. That is to say, of course, nothing in life is guaranteed, and it's quite possible that a system based on law-based property rights can lead to concentration of power and to exactly the forms of oppression that can be associated with concentration of morality in one case. It's my observation that at least some times and place in human history it doesn't work that way. Not that there may not be continued injustice, not that there cannot be too much concentration of wealth and power, but that a property rights system bolstered by law tends to grind down concentrations of wealth. And I think we can look to examples in our own history in particular that suggest that this is generally true, although not always, and that in many of the systems where property rights and intense concentration of wealth coincide, it's in large part because of limitations on property rights, namely the use of economic power to limit the property rights of the masses. I could go on about that, but that's my quick answer to the question. Understanding that the question is very difficult and my answer is very problematic and controversial.
With your vast experience, Judge Webster, with the CIA and seeing what these miraculous changes we've seen in the Soviet Union, and that, do you see one of these Soviet states being a more influential force compared to the others? And do you think that that will take a lead in bringing around this new constitution, this new era of the government, or is there some type of wild card that you see coming into effect in the near future?
We used to say that the Central Intelligence Agency was a not-for-profit agency in the sense of trying to prophesize what may come. And at least you work not from, intelligence does not give you the answer to that question. It provides an analytical base for what could happen in a series of scenarios. Trying to apply your question to the subject we have been discussing, it seems to me that one of the important trends will be whether or not the independent states, and particularly the Commonwealth of Independent States, searches for a way to advance their collective societies, and indeed their individual societies, upon principles that we would say fell within the rule of law. If instead the direction is a contest of force, who has the most divisions? Who gets the Navy? Who controls the strategic arms? Then I can see a flow of power toward particularly the Russian Republic, unchecked by value systems that reject this kind of concentration of force power and the potential for significant unrest in what was the Soviet Union. On the other hand, there are important political and economic considerations that make it imperative to those who are perceptive that these states be able to get along with one another. There was such dispersal of the instruments of production throughout the former Soviet Union that there is a dependency which has not yet been fully recognized. The smaller republics, particularly in the Caucasus, seem to me to have grasped the desire for independence well ahead of the Commonwealth of Independent States, and were the least competent to assume autonomy and independence. Pakistan, for example, as my information is incapable of feeding itself because it was directed under a command economy and a command authority to produce cotton. Now, that type of economic independence often forms the basis for a willingness to cede authority and collectivism without giving up the principle that we are giving you, the Commonwealth, or whatever other instrument is there, the authority. You are not telling us what the authority is. We are giving it to you, we the people. And if that system is followed, there is some hope for getting through this period without excessive violence. The Baltics seized their independence, but I don't think that's a good analogy. They were brought into the Union against their will. They preserved their traditions and their cultures, and it is, I think, not a good analog for the other republics, Russian republics, in terms of their dependency on what was a central form of government. Terms like emerging standards of decency, which we use in valuing our fundamental rights as we understand them, form a basis for moving into the future. And if there is recognition of these fundamental values, as others have pointed out today, rather than simply compliance with what the particular leader decides must be the law, there's again more hope for a truly democratic society emerging from this area that so long had not known freedom as we understand it. I don't know how optimistic to be. There are going to be huge challenges. You see some evidence of how the Eastern European democracies are coping with their problems. The important thing, it seems to me, that if we put our hope in law, we must see to it in all ways that we can, by assistance, by informity, by international pressure, that the judicial aspect, the judicial branch in each of those republics is not deprived of the authority to exercise their judicial judgment without fear of reprisal, both in terms of what I call the telephone justice system, where they're called and told how to rule, or in fear of the safety of themselves and their families. I just think that is crucial. That's the practical aspect of putting the rule of law in place in countries that have never really understood but always yearned for freedom.
Throughout much of the 1980s, much of our foreign policy seems to be guided by what could be referred to as the Kirkpatrick doctrine, referring to that's the G. Kirkpatrick, and the way that we should support authoritarian regimes, but not support totalitarian regimes. Authoritarian regimes would be the Shah in Iran, totalitarian would be the Soviet Union. As we've now entered the New World Order, does that distinction have any application to our emphasis on supporting the rule of law throughout the world? And if not, should we be focusing on other factors in terms of which governments we would support and which ones we would focus modify?
I think it's a very good question, and it's one that Professor Ngongi raised in his remarks. Now that the pressures of bipolar confrontation seem to be behind us, is there any longer an excuse for supporting repressive regimes in the interests of order or surrogate rivalries that surrogate wars that we used to fight with the Soviet Union in other parts of the undeveloped world. And I think we must come to grips with that, and indeed we are. We're seeing a change in Africa as the old leaders are finding pluralism is required for true democracy. Long-time rulers in Zambia, concerns in Kenya and in the Ivory Coast, Cote d'Ivoire, reflect, I think, a trend from within. The question is, are we going to interfere with that trend in some way in the interests of maintaining stability? I think we will be more reluctant to do that. First, because, at least with respect to this administration, there is a realization that we have to decide what are true national security interests in which we are able to invest substantial capital. That's a pragmatic approach. And another one is we must honor our commitment to let nations find their way to freedom. But there's also another question that came out of Desert Storm, it seems to me, and others are beginning to raise that question. I know Strobe Talbot, Time, has raised the question. Did we learn from our ability to cooperate together to deal with tyranny extending beyond its boundaries into Kuwait? Did we learn that there may be situations, using the Kurds as an example, in which it is in the interests of civilized nations, the United Nations, acting collectively to influence countries which do not respect those things that we collectively call protected by the rule of law? I think the answer is probably yes. There is more indication that we are willing to provide some form of pressure, absent actual armed intervention, on those countries. We've seen a little of that, a tenuous effort in Yugoslavia. There will be other situations in other parts of the world where we will say we're not going to support a despot. We are not going to support violence in a country. We will take steps insofar as we can to assure that those in authority come closer to reform and recognize democratic rights. I speak of hope I'm not being too long-winded about this. We speak of emerging democracies. You can contrast those with China, for example, which is the prime example of the fear of liberty and tilted strongly toward order. I think we have to encourage a number of these countries to take some risks in order, primarily through pluralism in their democratic systems, away from the one-party government, particularly in Africa, to take some risks to bring that balance between liberty and order more into balance than it has been in the past.
Do other members of the panel wish? Ikome.
I do find it a little bit beyond my ability to grasp fully everything that Judge Webster has said about this issue. With all due respect, I do feel that a certain amount of moral responsibility must be ascribed to the people or the nations of this world which created the old world order, which we see in the process of change now. He talked about geopolitical or national security concerns. But is it not the same national security concerns that proposed, that pushed the Western democracies, particularly the US, to, for so long, support regimes which otherwise would never have been supported, which are known to be blatantly repressive in these countries? Don't you think that there's a moral responsibility for the US and many other countries which have been known to support these regimes for the national security concerns to ensure that the changes that we see being stifled now because of the tendency to want to perpetuate the repression by the leaders in power should be addressed by them also?
Well,
and more particularly through the venue of the United Nations. And my concern comes out of the fact that in the past decades, I've seen the United Nations, the forum of the United Nations used with double standards by the US and several other countries. In one regard, it is used to justify their actions in invading Iraq and to try to ensure that UN Security Council resolutions are respected. But in the other case, we have not seen the same UN resolutions being pushed to be respected in other areas where the resolutions have been blatantly disrespected, like in South Africa or in Israel and in other places like this. How do we come to grips with this, with these double standards?
A fair question. I think I may not have been as clear as I would like to have been in addressing an earlier question. I was not saying what I thought should happen. I was saying what I thought was in fact happening, that with so many demands on our resources being made throughout the world, that our country was, and to some extent the United Nations, but our country was less willing to participate in that's a pejorative term, in making major investments in democratization in parts of the world that where we had in fact contributed to repressive regimes. I did not say that was right. I said I thought it was the fact of life in the present economy. We do have some responsibility. I think that we would like to see the United Nations, having demonstrated its capacity to act on clear principles, like to see the United Nations take a more vigorous role, to come into its own. For many years, we thought of the United Nations, I think, very critically. Some people, particularly in the Middle West, where I come from, thought of it as kind of a debating society without much impact. This was clearly an opportunity where it did have impact. I think the Copenhagen document reflects another effort to bring large groups of countries to focus on the underpinnings of the rule of law. And it remains to see whether that will be a consensus debating society or whether it will really act to implement those rights and obligations that were declared in that very important document. We do have to pay attention, particularly in Africa, to what changes are happening. They are, I think, in many places happening, and they may very well be attended by violence. There is no justification for retaining despots in the name of order alone. Now that the Soviet Union and its traditional counterpoint rivalry both engaged in this with surrogates in other parts of the world, and particularly in Africa, now that they are not involved, or at least, as Yeltsin says, are now our allies, we ought to be able to do something more constructive than our past history would indicate.
I think that one of the problems that still remains, it sounds a little bit like a paradox. There are new democracies now in Eastern Europe, in Russia, and so on and so on. And now perhaps for the first time over many years, United States of America, it would be nice if they will start to arrange some dialogue with Democrats. American dialogue with communists have been perfect. I understand, and well, my specialty is American constitutional history, and nobody has to prove anything to me. But when you look it from European, East European perspective, the effort to prove again and again, day by day, that America is for democracy, it's not wasted effort. Because contradiction, Yeltsin, Gorbachev, Democrats, communists, United States, of course, allies of communists. Slobodan Milosevic and Croatia and Slovenia, with whom were United States of America, with Milosevic. In Middle East, against Israel, etc. It is a stronger statement because diplomacy is much more complicated and so on. And there were certain reasons. And there were justifications. And the military balance. nuclear threat, and all these things are very, very serious. But those people there in Eastern Europe, they must know that first, not all the dangers are not over, and there is a huge, great democratic country who is on their side. And there are values that have been carried by this country through centuries. Those ordinary people must know America is with them.
We have time for one more question, I fear, because the reception will await. But, sir.
I want to pick up on a comment that Professor Graussen made earlier. I thought it was a very astute comment when he mentioned that the Declaration of Independence, after all, by definition, is an illegal act. The writing of the U.S. Constitution, by definition, was illegal because they violated the amendment provisions of the Articles of Confederation. So a lot of changes, a lot of wrenching changes, are almost by definition violations of the rule of law. And I wanted to just pose a general question to the panelists. You look at a situation like Peru today. I believe in the New York Times this morning, they mentioned that something like 80% of the population supposedly supports what President Fujimori is doing in Peru, which some of us find offensive. Who decides when the rule of law is being violated? Who can presume to decide when the rule is being violated and when you intervene?
Does anyone care to attempt this one?
That's a tough one to enter. I'd like to make one point, though. And we saw it in stark contrast in Iran during the revolution against the Shah. This was a country we thought was forward-leaning, becoming more liberal and civilized, and great friend of the United States. But it had no provisions at all for change, no provisions for the people to exercise their desire to assert their rights, which I consider to be another way of talking about where the rule of law derives. The higher authority philosophically may go beyond that man were created with certain rights, but anyway, the exercise of those rights. In the United States, we were that is, in the colonies, we were confronted with a situation in which we did not have an opportunity for petition for redress of grievances. And that is why the Constitution, in my view, is one of the great documents of the world, because it does provide for change. Not change every time a leader decides to change the Constitution, as we find in other parts of the world, but every time through a process that reflects the will of the people, we can have change. And that is change within the rule of law.
I fear that the rule of law applies here as well. And the rule of law imposes a deadline upon our activities today. I realize there may be some grievances from those who have questions, but I suggest the redress of those grievances will be at the reception on the 3rd floor of this building. Thank you.
I would like to thank Judge Webster, the panelists, and Bill Mock for this wonderful discussion. I hope that it has stimulated a lot of thought and gotten us thinking. I also want to thank the members of the committee, Joseph Ament, Chicago practitioner, Joe Cornwell, professor here, John Marshall, Lawrence Glick, another Chicago practitioner, Celeste Hammond, professor here, and Craig Peterson, Professor John Marshall, who was last year's chairman and who, in addition to giving invaluable assistance, was a very calming influence on me throughout this whole planning process. And lastly, I'd like to thank Dean Markey, who gave us tremendous support. Thank you very much for coming. The reception is on the 3rd floor.